Okay, looks like we have, whoops, we lost someone. He's back. Welcome back. Okay, we have both parties. Mr. Is it pronounced Usman? You need to unmute. Thank you.
Yes, Your Honor. Usman?
Did you wish to reserve 5 minutes for rebuttal, counsel?
Yes, please.
Okay. You may proceed.
Thank you, Your Honor. May it please the court. My name is Derek Usman, and I represent the appellant, Clinton Withrow. Appellant is asking that the trial court's judgment should be reversed because retaliation for reporting hazardous working conditions in the form of workplace violence is actionable under the Florida Private Whistleblower Act. By reporting unsafe working conditions in the form of workplace violence, the appellant objected to or refused to participate in an activity, policy, or practice of the employer, which is in violation of a law, rule, or regulation. And the three main points that I wanted to address.
Can I ask you a question? Because there was an opportunity to amend several times. What were the specific facts that your client alleged TICO knew about and they retaliated against him for reporting? Was there a propensity by the other person to commit violence that wasn't thwarted?
Your
I'm
Honor,
confused by what you're claiming happened here.
well, the allegations were there and the motion.
There's generic allegations. TICO, I think, agreed that generically you said things that they shouldn't, that no company should tolerate, but you didn't prove specifically what happened. And when it was called into question, apparently your client was allegedly the aggressor by all of the witnesses. So I'm trying to see what TICO did in this case. That was
well, Your
foreseeable.
Honor, yes, Your Honor. There was an investigation, and the investigation was unilateral by TICO. My client was not represented. He did not ask for union representation, and whether we would argue that he was not the aggressor, and in fact, he never struck the other individual, the other employee. The other employee was aggressive towards my client, and he struck my client, the appellant.
Was anyone arrested? The witnesses claimed your client had drawn a knife. The other person was defending himself. So one of those allegations, if not both, could have led to an arrest, but an arrest was never ensued in this case?
No, Your Honor. My client did not immediately file a police report. And a knife is not something that would be unusual for individuals working on power lines. It's a utility knife. It would be a tool that individuals would use during the course of their job duties. And
it's true, but it can be used in an aggressive manner to commit mayhem also.
Yes, Your
We
Honor.
don't know what happened in this case because nobody was arrested, and it wasn't necessary for the trial court to find, as a matter of law, a whistleblower violation was really never alleged. Your turn.
Your Honor, I would like to state that my client was or is approximately 50 years old, and the employee that assaulted him was much younger, 20 years old, and it was nowhere near a fair fight. And
well, it wasn't about the fight or who won the fight. It was about your client was fired because he lied as to what happened, according to TICO. So therefore, it couldn't be a retaliatory firing.
well, Your Honor, if the cause for the firing is, we're alleging that there was no grounds it was pretextual. For one reason would be that the other employee was, his family has contractual interests with Tico. And that is also evident because the other employee, the attacker, was not reprimanded or disciplined in any manner.
So you're saying that's a foreseeable hazard? I mean, under the statute, a violation occurs when the employer fails to take action to prevent a foreseeable hazard. All this after the fact, I'm not sure is whistleblower. It might be something else, but I don't see the whistleblower violation.
Yes, Your Honor, I have briefed that, and there is under the Pinder versus Bahamas Air Holdings case and Suzanne versus Nova Southeastern, if these acts are done within the legitimate scope of employment or ratification occurs by the employer, then that would be sufficient to establish a cause of action. Okay. And the investigation prompted by the complaint lodged by my client, when he lodged that client, that's when the investigation occurred. And Tico themselves, they brought in witnesses, and the witnesses testified and stated that there were numerous occurrences of workplace violence, that there was, these folks were out in public job work sites, and there was aggressive physical altercations that were commonplace. Additionally, and even though my client was portrayed as the bad actor, he was, they knew of, at least they mentioned that there were incidents of altercations among employees, and they had noticed that violence routinely occurred at these work sites. However, and additionally, when the event occurred, there was witnesses there and the supervisor was there, and the supervisor overlooked it, and he was even amused by it. He was laughing through the whole thing.
Okay.
I'm not sure that any of what those people saw matters in terms of our legal analysis. This case comes to us on a motion to dismiss. We don't weigh testimony. We look at the four corners of the document. So they've argued then the trial judge has found that you haven't pled sufficient ultimate facts to support your claim. What is it the trial court thought you should put in that you didn't, and why is that error?
Well, Your Honor, that would be foremost our concern, is that it was dismissed at the early stages of the case.
Well, I'm not so sure this is early. It's the third one.
Wasn't this the fourth complaint that was filed?
Yes, Your Honor. And the record reflects that there were, I fleshed out the allegations were fleshed out as much as possible. It was, I can turn a 10-page complaint into a 100-page complaint with just multiple allegations and with finite details. And that's where we were struggling with what the appellee argument was based on, more that these statutes are not actionable, that an OSHA statute, it's not applicable, or the Florida criminal statutes are not applicable under case law, that there are that they should be specifically applicable, and generally applicable statutes do not raise a cause of action.
Where you declined an opportunity to amend, saying it wouldn't matter. Just like you, I think you insinuated now, you could put 100 pages in there, or 10 pages. If the trial court rules against you as a matter of law, you had nothing else to add that you didn't already throw in there.
Yes, sir.
Okay, I appreciate that. Thank you.
And Your Honor, I have briefed your concern about how that the appellant was given the opportunity to amend the complaint. And we did plead sufficient facts that suggest the elements of the cause of action. And one thing that we were contesting was the applicability of the Erie and Kearns doctrines in Florida, and the conflict among those two avenues of thought. And however, at the pleading stage, we believe, the appellant believes that the pleading standards are not evidentiary standards, as Your Honor Casanueva stated, and all that is necessary is to plead ultimate facts. We don't need to plead our case at the onset. We are only at the pleading stage. We weren't able to get past the initial pleading stage, and we have specific allegations, and the allegations in the complaint should be the ones that are upheld as the truth, and not contested facts that the opposing counsel might present. And the law, rule, or regulations that we pled were for OSHA, general duty clause, which has been maintained in Florida in the case of Diaz versus Impex of Doral, and also Ramirez versus Bosch and Lom from the 11th Circuit Court of Appeals. And those cases both held that the OSHA regulations amounted to a viable cause of action under the Florida Whistleblower Act. And lastly, Your Honor, I would also like to implore the court that that the Florida Whistleblower Act is a remedial statute, and it's broadly worded in favor of protection, and the statute itself is silent as to whether the law, rule, or regulation should be specifically or generally applicable to the employer. However, the OSHA statute especially is applicable to TICO when, especially since it performs functions in public work sites. And we would also like to state, the appellant would also like to state that a narrow application would defeat the remedial purpose of the statute, especially in the instant case where the proceedings were at the beginning pleading stage. Therefore, Your Honor, appellant believes that the dismissal was premature at the pleading stage, especially when the plaintiff has pled facts sufficient to suggest that the elements of the causes of action will be met. The ultimate facts were alleged, and therefore the trial court's blanket order should be reversed. And we would ask Your Honors to hold that the case should be sent back to proceed.
Thank you.
Thank you, counsel. Mr. Gonzalez. You are muted, sir. There we go.
One day I'm gonna actually miss that, get that mark, Judge, and I apologize.
Not to worry.
Tom Gonzalez for the appellee, and I would begin by noting that the trial judge was extremely generous in giving the plaintiff every opportunity to plead a cause of action. What she wasn't able to do was to convince the plaintiff of what needed to be in this complaint. And what needed to be in this complaint was allegations of ultimate fact as opposed to unsupported conclusion that would state a cause of action under a statutory cause of action under a statute, which is very explicit in terms of what needs to be pled and what needs to be shown in order to have a cause of action. And your honors, in this case, what was lacking was, as is the focus of every suit brought under the whistleblower lawsuit, is what is being complained about. And it's established law. And the two cases that say it the most clearly are the Susan case and the Pender case that the plaintiff has cited. And both of those stand for the proposition that the statute means what it says when it talks about a law, rule, or regulation that is applicable to the business. And that is distinguished from laws that are applicable to the general public, including individuals who are involved in the case. And specifically, the Susan and Pender cases talk about the fact that wrongs such as assault and battery are not the kinds of things that are covered by the whistleblower statute, because they aren't applicable to the business unless the person committing them is acting in the best interest of the employer. And there are no facts in this case that were ever alleged to show that to be the case. And so the plaintiff was at all times left with the fact that what he was complaining about was assault and battery. Assault and battery wasn't the time of wrong that is covered by the Whistleblower Act. And what was added in the course of the amendments was the alleged violations of the general duty clause of the Occupational Safety and Health Act. But the problem with that is that although the plaintiff cited those statutes, and we can talk a little bit about whether there was ever an allegation that came close to a violation, what was alleged to have been violative of those statutes was that he complained of workplace violence, not the workplace violence that he says established this policy or course and conduct of violence. He never said he complained about anything. What he specifically and expressively claimed at all times in this case was that he complained of workplace violence in the form of assault. That's paragraph 56 of the last pleading, of battery. That's paragraph 67. And then when he got to the OSHA counts, what he talked about, he said he complained of workplace violence in the form of the assault and battery of this apprentice. And that's paragraphs 89 for count 3, paragraph 94 for count 4, and paragraph 109 for count 4. So at all times, although he attempted to couch it by conclusion in terms of alleging a violation of the general duty clause, he never got there because he couldn't. And I think what's important, because it was raised that this was an unrepresented employee, one of the things that I think took this case where it went was the fact that from the outset, the plaintiff had tried to use selected portions of the report of the investigation, which of course allowed the court to consider all of it as part of the pleading that was specifically incorporated into it. And contained in there very clearly is that when Mr. Withrow, when the plaintiff was interviewed, he was specifically asked and provided with union representation because he's a member of a union protected by the union contract. And by law, anytime he's going to be questioned about matters that might lead to discharge, he has a right to union representation. And he had a meeting with the union representative and then declined the representation. And everything that went from that all came from the fact of the incident with the apprentice, where he, in the complaint, he attempted to assume supervisory status by putting the words in the complaint, supervisor in quotes, when he specifically alleged facts that showed he was not the supervisor of the apprentice. He was the third on this crew and had no right to give any instructions with respect to anything else. And there was this back and forth. It was uncontested that the first person to draw a weapon was the plaintiff. Nobody ever contested that. And it was uncontested that it was the plaintiff that came to the apprentice after they had been talking to each other and put himself in close proximity to the face, and he was discharged. And in short, Your Honor, even if you take this as ever having been a complaint of workplace violence or condemnation of workplace violence, what the company owed to the plaintiff was an investigation, and he very definitely got that investigation. And the report, which was incorporated into the pleading, specifically said that each and every witness was talked to, and at the conclusion of that, it is clear that the plaintiff didn't like the results of the investigation, but he got the investigation that he said he was entitled to. And Your Honor, in this case, there's been talk by both parties of the difference between this court and the Fourth DCA with respect to the way to interpret the statute. I would suggest that in this case, it doesn't matter. But with respect to as for the reasons we've set forth, we clearly think that the view of this court is the correct one for all the reasons set forth in that decision and all the decisions that came before it. But with respect to that, again, I don't think that in this case it comes into it. What's important here is that there was an obligation to plead facts that showed a cause of action under a very specifically worded statute, and it wasn't done despite numerous tries. And we thank you for the time, Your Honor.
Thank you.
Thank you, counsel. Let me stop the clock. Counsel, you have your 5 minutes remaining, and right now, oh, there we go. You are unmuted. Okay, good.
Thank you, Your Honor. There's several points that I needed to address. Initially, the judge that entered the order to dismiss the complaint was different than the prior judge. The previous judge was absent that day, and there was a different judge covering the court call. If that's something material, I'd like for the panel to consider that. Additionally, the initial complaint did include an OSHA count, several OSHA counts, and furthermore, the more important thing that I wanted to address was that the laws that are applicable in Florida, there's even violations of discrimination that are actionable under the Florida whistleblower statute. Florida courts allow civil rights actions to proceed under the Florida Whistleblower Act. And just for the prong of ratification and whether this would interest TICO in some manner, it would be in the best interest of TICO because it allows for them to continue with their work. If they stopped work every time there was altercations, things would not proceed. The work would not be able to finish. And that is exactly why there's so much horseplay and physical altercation among the employees, because they let that to continue. And finally, the ethics complaint, that was done by my client. The appellant lodged an ethics complaint only after he was met with indifference by his supervisor and the second tier of management. They would not take his allegations seriously and were dismissive. Therefore, he proceeded to call the TICO hotline. Otherwise, it would never have reached that point to where there was an investigation. And but I do wanted to clarify whether if it was the initial complaint or the second complaint where OSHA was alleged or account was inserted. I'm not sure if it was the first or the second complaint, but irrespective of that, the OSHA complaints are a viable statute that are actionable under the Florida Whistleblower Act. Thank you, Your Honors.
Thank you. Well, thank both counsel. Have a happy holiday and please stay safe and well. We'll see you next time.
Thank you.
That will conclude this presentation or this session of the court by remote.